A babysitter in New Haven accused of beating to death a small child in her care.
Right now at noon, the final suspect of 3 teenagers is behind bars, accused in the vicious beating of an elderly man.
Sentenced tonight for the Medina County teenager who broke into the home of a 98-year-old woman, videotaped her sleeping before killing her and abusing her body.
A babysitter in New Haven is accused of beating a small child in her care to death. The woman faced a judge in court. 27-year-old Kunal Patel admitted she became angry when the baby, whom she was feeding rice and water, kept spitting it out. She then abused him, causing him to hit his head. In court, Patel stood expressionless with a translator by her side. She faces charges of manslaughter and risk of injury. Patel told police she had babysat the boy several times a week at her New Haven home. On January 16th, the unthinkable happened. New Haven police were called to the hospital after medical staff reported that the boy's skull was severely fractured. He had been taken to the hospital by his father.
Rushed to the home, secured it as the possible scene of a crime, and over the course of several days developed a suspect in the babysitter.
She didn't admit to this until January 24th, when she confessed to police that she had been lying, previously claiming the child had fallen backward. Then, she called the child's father to inform him of the injury.
This is her first time involved with the court system. I don't think she understood the seriousness of the situation she was facing at the time.
We went to the home to speak with the downstairs neighbor, who told police she heard a banging noise so loud that night she thought the ceiling was coming down. She reported hearing approximately 4 to 5 bangs on her ceiling, followed by a baby crying. She also heard the babysitter yelling in another language. Shortly after, the boy's parents arrived.
I can't say that the investigation is closed. We've certainly closed this portion with this suspect, but anything's possible in the future.
Patel is being held on a $1 million bond and is scheduled to return to court. The final suspect of 3 teenagers is behind bars, accused of the vicious beating of an elderly man. The judge had strong words for the teens who appeared in court. 2 of the 3 suspects in the brutal attack in Pinellas Park faced a judge for the first time just hours ago. Jasmine Burney and Xavier Peterson were officially charged in a case that has shocked the community. Both teenagers showed little emotion as they were brought into court in handcuffs this morning. You might be surprised to hear that Jasmine Burney's family did not attend the hearing. Looking around the courtroom, she realized she was alone while her charges were being read for the first time.
The reason we're here is because it's alleged that you used force, violence, or assault to put Charles Edward Clark in fear.
Along with the other 2 suspects, including Xavier Peterson, the teens are accused of violently attacking 83-year-old Charles Clark as he was removing oxygen tanks from his car trunk. Each teen has an extensive criminal record and already faces charges for previous crimes. The judge was clearly displeased and ordered that the teens remain in custody until their arraignments. The youngest suspect faces grand theft charges for returning to the scene less than 24 hours after the attack and stealing Clark's car. Due to the brutal nature of the crime, the court has not yet decided whether to charge the teens as adults. The high-profile case has prompted the judge to give the defendants strict instructions regarding discussing the details publicly.
Ms. Burney, it's real important that you not speak with the facts about this case to anyone except your attorney. If someone asks you about the case besides your lawyer, you need to say, I don't know what you're talking about. Do you understand?
Jasmine Burney is scheduled to return to court for her arraignment on April 22nd. An arraignment date for Xavier Peterson has not yet been set. It will be determined after a behavioral evaluation. Sentencing for the teenager who broke into the home of a 98-year-old woman, videotaping her while she slept before killing her and abusing her body. For the first time, we hear from Gavin Ramsey, the convicted killer. Ramsey's family claims that childhood abuse and the use of Zoloft as a teenager contributed to his heinous actions. He broke into Marvert Douglas Wadsworth's home, killed her, and hid her body in a closet.
I'm so sorry for what I did. I constantly live in regret and shame because of it.
It's been 9 months since Gavin Ramsey committed those acts against this woman. Her family had their only chance to speak the truth to Ramsey.
I find him to be pathetic and a coward and someone that preyed on the most vulnerable person that he could find and attack her in her most vulnerable moment, in the middle of the night when she was asleep.
She loved life. She loved being alive. She often talked that she just couldn't wait until she turned 100.
Marvert Douglas couldn't reach her 100th birthday, and her family believes that if Ramsey hadn't been caught, he would have struck again.
He broke into her house, watched her sleeping, and took videos of her sleeping. He then held her against her will, hit her, and strangled her. And I believe that he planned to kill numerous people and used my aunt as a warm-up, so to speak, for those other killings.
Before the judge sentenced him, Gavin Ramsey's mother took a significant portion of the blame, stating that she allowed her son to take the depression drug Zoloft, which she believes changed him.
Make me believe that my decision wasn't the ultimate cause of all of this. To simply say I'm sorry to a victim's family, that's not enough. You can't undo their heartache. You can't undo our heartache.
Gavin Ramsey was left in chains, where he will remain for life without the possibility of parole. A neighbor is shocked to learn that the robbery suspect found shot in his driveway was just 19 years old. The young man later died. Patrick Kemp, 22, now faces murder charges because his friend died during a robbery in which police say he was involved. Kemp frowned at some of the allegations and even smirked at times, a reaction that did not sit well with the homeowner, who found his friend wounded in the driveway.
He had that look on his face, but he didn't care.
That's what Archie Booker thought when he saw 22-year-old Patrick Kemp smirking as he appeared before a judge on murder charges. Kemp also frowned when the judge read part of the allegations.
The woman identified as Michael Richards did shoot Williams as he began entering the window.
Kemp faces murder charges after Riverdale police say a homeowner shot and killed 19-year-old John Dexter Williams on Birch Circle. In court, the judge explained that Williams and Kemp went to the home with a plan to break into it.
You did knock on the front door of the location, while the co-perpetrator, John Williams, did break through a window in the rear of the location.
That's when the homeowner shot Williams. Kemp was apprehended later. After being shot, Williams collapsed in Archie Booker's driveway. Booker was so shaken by what happened that he posted about it on social media.
Black brothers, it's not worth it. It's just not worth breaking in folks' homes because people are not going to stand for that.
Booker says he talked to the neighbor who shot Williams and mentioned that the neighbor is still shaken up by the incident.
His heart goes out to the family, but it happens. Again, what would you do if somebody break into your home?
The judge denied bond for Kemp. After the court hearing, a relative of Kemp's was seen crying, while Kemp's mother had no comment and quickly left the courthouse. A teenager will remain in prison for now after confessing to helping murder two of his best friends. Juan Carter, who admitted to assisting Rice Rhodes in the killings, is 18 now and could have been released. However, a judge decided otherwise.
I wish the outcome was different. If I knew this wouldn't happen, I wouldn't have hung out with Maurice and Larry.
That's Juan Carter. He turned 18. Back in 2016, he confessed to helping Bryce Rhodes kill teenagers Maurice Gordon and Larry Ordway.
He put a rag in his mouth.
Carter took a plea deal and agreed to testify against Rhodes. He was sentenced to 10 years, but since he just turned 18, he was eligible for probation. His attorneys pushed for his release from probation.
I truly believe that Mr. Carter is a victim of Bryce Rhodes, along with everybody else. All these kids, I think, were basically influenced by him, and obviously to a horrible degree.
However, the families of Gordon and Ordway begged the judge to send Carter to an adult prison.
You could have saved them their lives. You could have saved them. But did you? No, you did not.
Judge Charles Cunningham agreed with the families and ordered Carter to continue serving his sentence in an adult prison.
Fairness in this case would probably say, we need to put a needle in your heart. That's the only fair way to resolve. Justice, however, doesn't necessarily mandate that we kill you, much less keep you incarcerated for any particular period of time.
Since Carter has already spent 2.5 years in juvenile detention, he is eligible for parole. Bryce Rhodes, on the other hand, faces 2 murder charges and an additional charge at his trial. In a Youngstown courtroom, a woman gave an emotional apology as she was sentenced for killing a teenage girl. The shooting occurred in May, and the pain remains very real for everyone involved in this tragic case.
No more graduations, no more birthdays, no more holidays, no more anything.
The courtroom was filled with emotion as 29-year-old Shamara Green was sentenced to 7 to 9 years in prison for the May 19th shooting death of London Jones.
I know I can't change it, But I'm sorry. I'm sorry.
You bear the responsibility for that. Someone is injured. You can't call that an accident. It's an intentional act because you know what a gun can do.
Green pleaded guilty to charges of involuntary manslaughter. Police say she was at an outdoor party on Carroll Street, arguing with someone when she pulled out a gun and fired several shots. London was standing on the sidewalk when she was hit.
I hurt much as they hurt, and that if I could change it that day, I would love to change it. It's not that I don't go about, that I think about, what had happened.
Dynasty Jones, London's sister, says the death shattered her, and it hurts even more because Green was so close to their family.
We loved you like you was ours, but I don't think you cared and you loved us like we loved you. I don't think you cared about me or London when you pulled that gun out and started shooting at me. I feel you didn't care whose lives was in your hand at that moment. My baby sister was out there.
Like, I talk to them kids every day. Like, I see them kids every day. I want to see them all the time. I picked them up from school. Like, they was my own.
London's mom described her daughter as uplifting with a bright soul.
My baby was to love her. Her smile would brighten up a room. The love she gave, you could feel from miles away.
In Trumbull County Court, former Hubbard Mayor Richard Keenan changed his plea to guilty on 20 counts of crimes, including rape. Keenan, visibly shaken, agreed to a life sentence with the possibility of parole after 10 years. The abuse, which began as early as September 2013, involved a victim known to him who was just a child at the time.
The victim some closure. It obviously keeps this young child from having to testify, and I think it's a good result given all the facts and circumstances.
Keenan's family was emotional, lashing out at the media and trying to block cameras from capturing him after the hearing. Prosecutors noted that this response highlights how challenging these cases are for everyone involved.
Yeah, people have feelings the whole time. We have feelings. He has a family. You don't care about his family.
I think what we've seen today is they're tough, right? They're tough on everyone. They're tough on the defendant's family. They're tough on the victim's family. And obviously, our concern lies with the victim's family.
Keenan remains free on bond until his sentencing. A girl on her way to school was grabbed and raped in a vacant home in Highland Park. Her alleged attacker appeared before a judge. 24-year-old Ramirez Dewberry, the man accused of raping the girl, had his family in court to support him, claiming his innocence. This is the first time Dewberry, a homeless man, has appeared in court. Police believe he raped the girl in December while she was trying to catch a school bus.
He would never rape a girl. He would never do that. Never.
That's Ramirez's sister, Soli, who lives in Detroit. Soli is defending her brother.
He used to squat. That's the only thing he's probably a victim of or guilty of is being a squatter.
Police say Ramirez dragged the girl into an abandoned home where he attacked her before letting her go.
They are framing him. He has a child on the way. He is not a bad man.
Police say they found Ramirez's cell phone in an abandoned home where he might have been living. They also discovered DNA evidence linking him to the crime.
Whatever DNA and all that other crap that they saying they found, they're lying. If anything, they probably found some clothes or something of his that he may have left behind in an abandoned home. But he is not a rapist at all.
Soleil says her brother doesn't have a job but composes music and writes poetry. Police arrested Ramirez in Howell as he arrived on a megabus from Chicago.
Until I talk to him and he tells me himself that he raped an 11-year-old girl, he is not a rapist.
Ramirez faces 4 felony charges, including criminal sexual conduct in the first and second degree. In August 2020, Officer Tamaris Bohannon responded to a call involving Thomas Kinworthy in St. Louis, not knowing it would be his final mission. Kinworthy now hopes to dodge justice, but the final verdict is yet to come. As the jury reviews the compelling evidence, it's captivating to see the criminal trying to avoid punishment by pleading mental illness.
As to count 1, we, the jury, find the defendant guilty of murder in the first degree, as submitted by instruction number 5. As to count 2, we, the jury, find the defendant guilty of armed criminal action as submitted in instruction number 14. As to count 3, we, the jury, find the defendant guilty of assault of a law enforcement officer in the first degree as submitted in instruction number 22. As to count 4, we, the jury, find the defendant guilty of armed criminal action as submitted in instruction number 26. As to count 5, we, the jury, find the defendant guilty of second degree as submitted in instruction number 32. As to count 6, we the jury find the defendant guilty of armed criminal action as submitted in instruction number 36. As to count 7, we the jury find the defendant guilty of burglary in the first degree as submitted in instruction number 38. As to count 8, we the jury find the defendant guilty of armed criminal action as submitted in instruction number 42. As to count 9, we the jury find the defendant guilty of resisting arrest as submitted in instruction number 44.
Mr. Honor.
As I call your number, will you please rise and respond to my questions? Juror 144. Is the verdict I just read your verdict in this cause? Yes. So says the juror. Juror 435. Is the verdict I just read in your verdict in this cause?
Yes.
So says the juror. Juror 443. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 359. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 544. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 576. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 14. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 646. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 427. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 190. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. Juror 53. Is the verdict I just read your verdict in this cause? So says the juror. Juror 511. Is the verdict I just read your verdict in this cause?
Yes.
So says the juror. So says the juror and all the jurors, Your Honor.
Anything further on behalf of the state? No, Your Honor. The court will accept the verdict of the jury. Are you requesting a conditional sentence?
No, Your Honor.
We will set this case for sentencing on June 27th at 1:30.
Yes, Judge.
That'll conclude the record.
Thank you, Your Honor.
That'll also conclude
John Tyrone Roddy Jr., 24, is accused of raping a female student at Winthrop University. Here are extracts from his bond hearing.
You have the right to hire a lawyer of your own choosing, of course. And if you wish to do that, you just need to let me know at this time what you want to do about a lawyer.
How much do those cost?
How much does a lawyer cost? For these charges, I couldn't tell you. Well, let me ask you some personal questions about this then. You're 24?
Yes, ma'am.
And who do you live with?
My father.
Who else lives in the home?
Just me and him.
Where's your mother?
She stays in North Carolina.
So they're divorced?
Separated.
Separated? And you're not working?
I didn't know.
You were working until September? You're not married? You don't have any children? Have you ever been arrested? How are you paying for this car?
I was working, so that was taking care of it. Since I go to school, I was going to New York Tech. I got a bunch of aid.
So are you going to York Tech or you were going to York Tech?
Still going to New York Tech. So,
Is this your dad?
yes, this is my son.
Mr. Wright. Mr. Wright, this is his bond hearing. To recap, I was just telling him the 2 charges. He has been arrested for criminal sexual conduct first degree, and he has been arrested for kidnapping. The first warrant accuses him of digitally penetrating both vaginally and anally the victim outside Margaret Nance Hall on the Winthrop campus. In the second warrant, charges him with kidnapping her, seizing her and confining her against her will in the parking lot outside Margaret Nance Hall. In order to do this, these are both felonies, and they do both carry up to 30 years. There is a victim advocate in the courtroom. Do you want to speak for her, Officer Wiles?
I'm going to speak for her.
Okay. The victim advocate or the detective from Winthrop's Police Department, Wiles?
Yes, sir.
Can speak on behalf of the alleged victim, and if that's what you wish to do, we will hear from you at this time.
Your Honor, she does not wish to be here right now. I spoke with her and her family. She is fearful for being here right now.
Is there any relationship between the two?
There is not.
Do they know each other?
They do not.
Is this something you would call a random act?
Stranger, CSC. Would you like me to give you some facts?
Please.
Your Honor, we received a call last night around 2:20, 2:25 in the morning from several witnesses at Margaret Nance Residence Hall that actually observed the act. And they called us, so an officer was in the area whenever Mr. Roddy attempted to leave. He was apprehended fairly quickly after that. And according to our victim, she was simply walking from a friend's residence hall across campus to her residence hall, at which point she was approached from behind by Mr. Roddy here, and she was taken with physical force or threat of use of a weapon to a corner of the parking lot where she was asked to remove her clothing, at which time he digitally penetrated her, as you said, saw in the arrest warrant, anally and vaginally. She was screaming, and several witnesses saw her and quickly reported it and came out and called us.
What's the weapon?
There's no weapon that's been found at this time. Your Honor, it's still under investigation as possible what that weapon was.
Mr. Roddy, you understand the allegations against you? You understand what you're facing? I think I have gone over all your rights with you. Do you have any questions about any of those rights? Any questions about the charges or any questions about your court dates?
I still have an attorney, right? You still have an attorney?
Yes, you're going to have an attorney.
So I'll put this on all of him?
Yes.
Okay.
Yes. Dave, do you have any questions for the court?
No, only for my son.
Okay. Mr. Roddy Sr.,
Yes, ma'am.
do you know, is it true your son has never been arrested for anything? That's what he did.
Nah, that's what's got me kind of he's my son.
That's what he tells me, and that's what the police tell me.
So I don't know y'all. I'm trying to figure it out.
When you set a bond, you've got to make sure of 2 things. I've got to make sure that that you will appear in court, that you're not a flight risk, and that you will not be a danger to the community. It's mind-boggling. I can't make that determination.
Well, Your Honor, if I may,
let me tell you. I'm denying this bond. I'm denying this bond. You have the right to appeal this to the circuit court judge. By that time, maybe you can talk to your father, and you'll be able to speak to the other judge. But I cannot. This is every co-ed and we were co-ed parents first name. These are his sons.
The incident centers on Jerry Burns. On December 19, 1979, in Cedar Rapids, Iowa, he took the life of Michelle Martino. Nearly 40 years later, police finally connected Jerry to the murder. The prosecutor skillfully revealed the complex and horrific details of the crime, capturing everyone's attention with the chilling revelations.
In the Iowa District Court in and for Lynn County, State of Iowa versus Jerry Lynn Burns. Trial information. Comes now Jerry Vandersanden as a prosecuting attorney, and in the name and by the authority of the State of Iowa accuses Jerry Lynn Burns of the crime of murder in the first degree, committed as follows. That the said Jerry Lynn Burns, on or about December 19th or 20th, 1979, in the county of Lynn and state of Iowa, did unlawfully and willfully, having malice aforethought, willfully, deliberately, and with premeditation, Michelle Martinko at 2400 Edgewood Road Southwest, Cedar Rapids, Lynn County, Iowa, in violation of Section 707.1, 707.2, Sub 1, Sub A, Iowa Criminal Code. A true information, signed Nick Maybanks, First Assistant Lynn County Attorney. To these charges, the defendant has pled not guilty. Ladies and gentlemen, over the course of the next 2 weeks or so, you're going to go on a journey back in time. The evidence in this case will take you to the year 1979, specifically 6 days before Christmas, December 19th, 1979. Michelle Martinko was a girl out on the town. She was young. She was just a senior in high school. You'll hear people describe her as a happy young lady, friendly, sweet, and kind. She was well liked by her peers. She was viewed as mature for her age. She would talk to anyone she considered to be a friendly face. Those in her class, those in the concert choir with her, and those that were in music or on the twirling squad with her. That night, you'll hear that she attended a concert choir banquet at the Sheraton Hotel on the southwest side of Cedar Rapids. She was seen by many people there that night by herself. You'll hear she left the concert choir and went to the Westdale Mall that had just opened in October of 1979. Again, by herself, to check out a new coat. She was dressed well. She had a rabbit fur coat on. She had a black dress on. You'll hear Michelle was the type of girl, by virtue of the way she looked and her personality, would sometimes attract the attention of older men. Michelle had been dating a young man who had just graduated from Kennedy High School by the name of Mike Wyrick, who at that time was off to Iowa State to attend as a college student. There was another young man with whom she had a previous relationship and with whom she was still friendly that was also a part of her life, Charles Andy Seidel. You'll hear from both of these men, now in their 50s, throughout this case. The evidence that you'll have an opportunity to consider and examine will come from what has been pieced together over the last 40 years since Michelle was murdered. Through the testimony and the evidence in this case, the state will bring to life for all of you a moment in time where numerous young souls converged upon a new and exciting venue in Cedar Rapids on a busy shopping night in December of 1979. As you'll see from their testimony, life went on for the individuals that you'll hear from. We submit to you that when they testify in this case, they will not appear just as witnesses in their late 50s or early 60s, a good chunk of their lifetime behind them. Instead, you'll hear evidence and perceive their testimony through the youthful, gleaming eyes of teenagers in 1979. As folks who had so much life ahead of them and so little behind them at that time. As they speak to you about their interaction with their friend, Michelle Martinko, that night. For a brief period of time in this trial, Michelle will be brought back to life for you to understand what kind of person she was. And the evidence will show you that nobody in her life who knew Michelle would wish any harm upon her at all, nonetheless want to kill her. The evidence will show that just mere moments after these folks interacted with their friend Michelle Martinko, she was killed. You'll hear from witnesses whose life has gone on, but they still hold vivid and tragic memories of her from that night. You'll have an opportunity to assess their credibility, their bias, and their demeanor, and you will consider what it must take to hold visions and memories for 40 years. As I said, you'll hear evidence of Michelle's personality. You'll hear on that night she was dressed to the hilt. Black dress, rabbit fur coat. As I said, you'll hear from people who interacted with her that night and knew her well. They will describe how she appeared, and they'll give you a description of her demeanor as well. The stories of their interactions with her are ones that have survived the last 40 years. You'll hear from Kurt Thomas, who knew Michelle from being in a play with her called Pippin. He saw her that night while he was working at the Chess King at Westdale Mall and took his break to hang out with her for a bit. They went to the Orange Julius, where he grabbed a bite to eat and talked while he was on his break. He will describe to you in vivid detail his recollection of her appearance and her demeanor that night. They spent his break together and then walked back towards the Chess King, where he returned to work. He will testify that she was preparing to leave the mall at that time.
You put your hand on the counter. You may have got a cold drink from a convenience store and drunk that drink from a straw. You may have used a public restroom in the courthouse, touched the faucet, touched the lavatory. You may have shaken hands with another member of the jury. What we're going to learn over the course of the next couple of weeks is that in each of those acts, we leave a trail. We leave a trail of our biologic specimens. We leave trails of DNA. In addition to the trails that we leave, we also cross trails of other people that we meet throughout the course of the day. Someone who may have coughed, put their hand on a bus handle, may have sneezed, may have spilled something on a bench, may have brushed up against us, shaken our hand. In each of those instances, not only do we have a trail, but they have left a trail that intersects with us. What you're going to hear over the next couple of weeks is that those trails tell us what we are, but they don't necessarily tell us who we are or where we've been. There's no question that the Cedar Rapids Police Department and law enforcement in the investigation of this horrifying death were determined and pursued leads best available to them at the time. And no one is going to be critical of that determination. And no one in this courtroom at any point is going to be critical of Michelle Martinko. There was no reason for her to die, and there was no reason for any violence to be inflicted upon her. But the evidence is also going to show that at some stage this investigation was diverted. It too took a trail. And we're going to demonstrate to you that we believe that the diversion of this trail led to investigators believing that Jerry Burns was the killer of Michelle Martinko. In fact, when he was questioned in December of 2018 on the anniversary of Michelle Martinko's death, It should come as no surprise that he could not say where he was on that date in 1979 at a well-traveled mall, a busy commercial area in Cedar Rapids, Iowa. In 1979, the evidence will show that Jerry Burns was a married man. He was living with his wife and his 2 young children in Manchester, Iowa, the town in which he was born and raised, where his family had farmed, where he had eventually established a successful business. He could not identify where he had been in 1979, and the construction, given that he made some admission en route from Manchester, Iowa to Cedar Rapids, is a spin that is not accurate. Even though we are going to hear, as you've heard this morning, some dramatic statistics about DNA and correlations of DNA and consistency of DNA and DNA that cannot be eliminated, those statistics, men and women of the jury, are only as accurate as the investigation on which they are founded. They're only as accurate as the integrity of that investigation, the consistency and the care with which the items that DNA was collected from were handled throughout the course of the past 40 years. They can tell us a lot about what can be discerned and what cannot be discerned. But it's going to be very important for us throughout the course of this trial to be sure to recognize what those numbers mean and, more importantly, what they do not mean. We're going to have a distinguished forensic scientist who's going to help you and help us not only understand what those numbers mean, but also about the integrity of the investigation from which those numbers were drawn. You're going to hear, and our expert will demonstrate to you, an expert not only on genetic science and genetic investigation, but also on crime scene investigation, that the handling of the evidence, the likelihood of the intersection of trails of complete strangers demonstrate that the trails do not inevitably lead to Jerry Lynn Burns. Those divergent paths, I repeat, do not inevitably lead to Jerry Lynn Burns. And those scientific paths also demonstrate why it cannot be said not only that Jerry Lynn Burns was not the killer of Michelle Martinko, but they will also demonstrate that Jerry Lynn Burns is not guilty of the killing of Michelle Martinko.
Good afternoon, members of the jury. Our court attendant informed me that you have reached a verdict. Is that correct?
That is correct.
Okay, if you would please hand that verdict form to Ms. Larson. Thank you. The verdict appears to be in order. The members of the jury, through the foreman, have signed verdict form number 1. We, the jury, find the defendant, Jerry Lynn Burns, guilty of the charge of murder in the first degree, dated this 24th day of February 2020, signed by the foreman of the jury, Mr. Lynch. I will now poll the jury. I'm going to ask you simply whether this is your verdict. Rather than name each of your names, I am going to proceed by seat number, and it will be in the order, the top seat on my right. We will go through that top row, and then we will proceed in the front row of jurors, beginning again to my right, nearest the back wall of the courtroom. Juror number 1, is this your verdict? Juror number 2, is this your verdict? Yes. Juror number 3, is this your verdict? Yes. Juror number 4, is this your verdict? Yes. Juror number 5, is this your verdict? Yes. Juror number 6, is this your verdict? Yes. Juror number 7, is this your verdict? Yes. Juror number 8, is this your verdict? Yes. Juror number 9, is this your verdict? Yes. Juror number 10, is this your verdict? Yes. Juror number 11, is this your verdict? Yes. Juror number 12, is this your verdict? Ladies and gentlemen of the jury, thank you again. At this time, we will excuse you. I will be in just a few minutes to thank you again and answer any questions that you have.
Please rise to the jury.
The record should reflect that Mr. Burns, as well as counsel, have remained in open court. The jury has retired again to the deliberation room. I will schedule a sentencing in this matter in the normal course. It will be approximately 6 weeks from now. I direct the 6th Judicial District Department of Correctional Services to prepare and file a pre-sentence investigation report and make that available to the attorneys as well as the court with no less than 5 days prior to the date scheduled for sentencing. Mr. Burns, you do have the right to file a motion in arrest of judgment. A motion in arrest of judgment, as well as any motion to seek a new trial, must be filed within 45 days of today's date and at least 5 days prior to the sentencing date that will be scheduled in the normal course. Mr. Spies can certainly answer any questions you have regarding those motions, but those motions are essential and must be filed prior to that sentencing date if you wish to pursue those motions. Anything further that we need? Well, at this point, Mr. Burns will be held without bond, given the fact that this is a forcible felony. Any further record we need at this time, Mr. Maybanks?
No, Your Honor.
Anything further we need at this time, Mr. Spies? Okay, thank you, folks. We will be adjourned.
In the end, it was up to the judge to determine Jerry Burns' fate. Would justice finally be served for Michelle?
At the risk of repeating myself, I do want to make sure that our record is very clear that with regard to the motion for new trial filed May 29 and supplemented on August 5, 2020, that the court finds that the verdict rendered on February 24, 2020 was contrary neither to the weight of the evidence nor to the law, and that the court finds that the greater amount of the credible evidence supports the jury's verdict. At this time, a judgment will now enter upon the jury's February 24, 2020 verdict, finding Jerry Lynn Burns guilty of murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2 Code of Iowa. Pursuant to Iowa Code Section 902.1, Jerry Lynn Burns, you are now remanded to the Director of the Iowa Department of Corrections for the rest of your life. The Lynn County Sheriff shall transport Mr. Burns to IMCC Oakdale when there is bed space available. Mr. Burns will receive credit for each day that he spent in the Lynn County Sheriff's custody, dating back to his arrest on December 19 of 2018. Pursuant to Iowa Code Section 910.38, Jerry Lynn Burns shall pay a sum of $150,000 to the estate of Michelle Martinko. In the event there is no estate opened, the payment of any monies shall be paid to the heirs of Michelle Martinko. Those heirs shall be determined pursuant to Iowa Code Section 633.210. Pursuant to Iowa Code Section 901.5, subsection 8A, Mr. Burns is ordered to submit to a DNA profile upon request, if Mr. Burns has not already done so. The reasons for the court's sentence today are short and very simple. The Iowa legislature prescribes the sentence for a Class A felony. The jury on February 24, 2020 found that the state proved beyond a reasonable doubt each element of murder in the first degree. Therefore, this is a mandatory sentence. There is no possibility of parole. Any costs that are associated with the prosecution of this matter will be assessed to Mr. Burns, in addition to any victim restitution that is later set out in a pecuniary damage statement. The court will order that if there is an additional statement of pecuniary damages, that shall be filed with the court within 30 days of today's date. Mr. Burns, you do have the right to appeal. In order to appeal, you must file a written notice of appeal with the clerk of the Lynn County Court within 30 days of today's date. If you fail to file a timely notice of appeal, the Supreme Court of Iowa will lose jurisdiction to take up any appeal you wish them to examine. As I stated earlier, there is no right to an appeal bond. Any appearance bond will now be exonerated, but Mr. Burns will be held without bond pursuant to Iowa Code Section 811.1. Anything further from the state?
No, Your Honor.
Anything further, Mr. Spees?
Only one matter, Your Honor. The court in its imposition of sentence said that costs would be assessed against Mr. Burns, and I understand this morning there was a statement filed by the clerk of court not itemizing those costs, but we will be requesting a restitution hearing in accordance with Section 910.3.
So you'll be seeking a restitution hearing?
Yes.
Okay. I couldn't hear you, sorry. All right. We will schedule a hearing on that request. If there is nothing further, we will be adjourned. Parties are excused.
On September 28, 2016, in southwest Detroit, Jeremy Lee brutally attacked pregnant Amanda Lynn Benton. The horror of this crime eventually reached the court. When confronted with his actions, Jeremy showed no remorse, his expression remaining indifferent.
Your Honor, since I just got this, I think it's appropriate to have the charges read against basically.
Thank you. Okay. So both Mr. Barnes and Mr. Lee, you are both charged with count 1, homicide, felony murder. This is a felony with a maximum penalty of life without parole. Mr. Barnes, you are charged with also homicide, murder, first degree, premeditated. This is a felony with a maximum penalty of life without parole. Mr. Lee, you are also charged with homicide, first degree, murder, premeditated, juvenile defendant. This is a felony with a maximum penalty of life without parole, or a minimum sentence of 25 to 40 years, and a maximum sentence of at least 60 years. Count 4, you are both charged with assault, pregnant individual, intentionally causing miscarriage or stillbirth. This is a felony with a maximum penalty of life or any term of years. And Mr. Barnes, there is also a habitual offender fourth offense notice because of prior convictions, in which the maximum penalty, there will be a mandatory 25-year sentence. Oh, strike that. Because of there being a mandatory 25-year sentence, the maximum penalty is life or a lesser term.
As the victim's mother delivered her statement, her trembling hands were heart-wrenching to witness. Yet, the criminal remained eerily calm, a fact that was both astonishing and unsettling.
My name is Florence Harper. I am the mother of Amanda Lynn Benton. First off, I would like to thank the court for letting me make a statement. I cannot find the words to say for what was done to my daughter Amanda and my granddaughter Angel. I'm sure there's a lot of anger and pain in this courtroom here today. One thing I cannot understand is how his family is angry with my family. If they were in my shoes, they would want justice too. Amanda was a beautiful woman with the biggest heart of anyone I've ever known. She would help everyone she could. Trust me, she has had her problems as anyone else in this courtroom. But she and her baby did not deserve what was done to them. My anger is for the two people that brutally them. I will never understand how anyone could do this to anyone. This is pure evil. September 26, 2016 is the worst day of my life. As soon as I got the call, no one could get a hold of her. We all knew something wasn't right. One thing I know is my life has forever changed. I cannot express the pain, the anger, and my emotions. I want to make this clear. He did not murder one person. There were two lives taken in the worst way I could have ever imagined. I never thought one of my children would be murdered, especially the way she was. The thoughts of what was running through her mind knowing she was going to die. And if it wasn't enough, after beating her, choking her, breaking 4 bones in her neck, they knew she was dead. And to hear him say he put her to sleep, I would still have to say he murdered them both. I don't feel my family is getting the true justice that we deserve. He should be gone for life. I do not agree with this plea at all, because if he gets out again at the age of 16 and to have a mindset to cooperate and taking actions in this, he had many opportunities to stop it, to walk away from it, and not to be a part of it. But he chose to go from the beginning to the end. I don't know if this was a thrill kill, just so they'd know what it would feel like to kill a pregnant woman. I don't understand, you know. One thing I can say is, by the time his first parole hearing will come up, her father and I will probably both be with them. But she has 4 sons, 2 that will have memories of their mother for the rest of their lives, and 2 that won't even ever know who their mother was. Amanda was one that would go down there and feed the hungry bums on the street, pass out toothbrushes to the girls on the streets. She was helpful. She always put a smile. They destroyed my whole entire family. I'm 50 years old, and I don't even know who I am anymore. Who am I going to become? I used to know who I was. One day, I wake up, I'm a mother of 3. The next day I wake up, I'm a mother of 2, and I don't understand why. And then to burn her. So we can't even have a proper goodbye to her. Why burn her? The only thing identifiable on my daughter was a tattoo on her stomach. And I thank God that I was not the one that went to the morgue to identify her. It was my ex-husband, my daughter's fiance, and my son. And just what I was told, I can picture it. And that picture will never leave my mind, ever. True justice would be for him to never make it out. And I pray that he suffers 1,000 times the fear, the torture of what my daughter Amanda did, because that's what's deserved. And I would just like him to know her sons will be grown men, probably with families of their own, when it comes up time for a parole hearing. And they will be there, and this family will fight to the end for the full 60 years to be spent in the prison. And I thank you.
I want to thank this court for allowing me to speak on behalf of my daughter, Amanda Lynn Benton, and my granddaughter, Angel Dolores Tybo. This monster has put this family through hell. He didn't just murder my daughter and my granddaughter. He has broken the family. He has broken the family down to where the pain and the hurt will never go away. There's not a day that goes by that I don't think about my daughter and my granddaughter that I would never get the chance to. Amanda was not just my daughter. She was my heart. She was my soul. She meant the world to me. She was my best friend. Someone I could talk to about anything. and everything. Amanda was a daddy's girl. We talked just about every day on the phone, if not by phone. It was on Facebook. And it always ended with her saying, "Daddy, I love you and thank you for always being there." I will never hear those words again. I will never get to hold my daughter in my arms and tell her everything's going to be all right. I will never get the chance to walk down the aisle and give her away to the man that loved her so much. And she loved and was so happy with. I'm not going to get to do any of these things with her ever. And I'm standing here reading all of this to you, but in all reality, words cannot express just how much hurt, the pain I feel. It will never go away. When I go to bed at night, there's not a night excuse me.
Take your time.
There's not a night that I don't hear her calling, "Daddy, help me. Daddy, help me." Please, Daddy, help me. I don't sleep no more.
This is the time for sentencing. This is your opportunity to make a statement if you'd like to. You don't have to make a statement, but this is your opportunity if you'd like to make a statement to me or anybody else. All right, I'm prepared to move forward with sentencing. There was a sentence agreement in this case between the prosecution and the defense that I'm prepared to follow. First, I would note that you have certain appellate rights. Those appellate rights include you may, if you choose to do so, file an appeal to the Michigan Court of Appeals. And the appeal would be by leave, not by right. If eligible, you can have court-appointed attorney represent you in that appeal. But any appeal would need to be filed within 42 days of the release date. The form that is in front of you now sets forth your appellate rights. I ask you to review and sign that form, acknowledging you understand your appellate rights if you do. Appellate rights form. And I understand you signed the notice of appellate rights, is that correct?
Yes, Your Honor. Appellate rights form has been signed. Here's a copy to take with him.
In terms of your sentence, you must comply with a $60 DNA testing fee, $60 for state costs, $130 crime victim assessment, $1,200 in court costs. Attorney fees, you retained?
I'm retained.
Restitution to be determined, and you'll receive credit for 164 days that you've already served. Sir, in terms of the case, this is a senseless and brutal murder where you assaulted, strangled a pregnant woman. You threw her in the trunk of a car. You took her to her abandoned building, residence, and you set her on her and her underwear shop. I'm going to sentence you to 25 to 60 years in the Michigan Department of Corrections. That concludes the sentence.
Thank you, Your Honor.
Big thanks to our viewers for joining the courtroom journey with us. Your interest in the stories of justice is what keeps our channel alive.